Ladies and gentlemen, it is a pleasure to welcome you to the University of Arkansas School of Law today for a Hartman-Hotz lecture dealing with the poor and the law, how the law should deal with the poor, which is a broad label for several independent endeavors that are going to, I think, become clearly related as the afternoon proceeds. I'd like to introduce you to the idea of the Hartman-Hotz lecture, which is an object, I think, of great success on the University of Arkansas campus. Hartman-Hotz, Professor Hotz, was a member of this faculty in the law school who had attended Harvard Law School, had completed a history degree in the University of Arkansas, and died at a very untimely age. And his family established a fund to support this lectureship in his honor. It is now in its 27th year, I believe. Among the earlier lecturers, in fact, I believe the first was Chief Justice Warren Burger. And among the obligations of the trustees who oversee the fund is to ensure that not only the history department of the law school are represented by its lecturers, and also that the university ideal of controversy and challenge is met by the lecturers who are invited here. It's a pleasure to have a former Hartman-Hotz lecturer, the Right Honorable Henry McLeish, and I'm very grateful too that he and his class have consented to lend us their room for this hour. But Henry McLeish was the Hartman-Hotz visiting professor, given that he was the minister who oversaw, among other things, the devolution of Scotland from the United Kingdom, and went on to be First Minister of Scotland, the head of the Scottish government. He's now a visiting professor here, teaching in our law school at Fulbright and two others. But among other lecturers have been distinguished historians, not the least being Jack Rakove and Sir David Kennedy, as well as a number of legal theorists, perhaps better known to our panelists, not the least being Stanley Fish, Jeremy Waldron, Lord Butler, your Harvard colleagues Mark Tushnet and Fred Schauer, all of whom have been brought to campus under the auspices of this trust, and from each of whom we have benefited greatly, and whose challenge to the university community was demonstrable and long-lived. It's a pleasure on behalf of the committee to welcome you here. The members of the committee include the Dean of Liberal Arts, the College of Arts and Sciences, Dean Robin, who could not be here today, Dean Stacy Leeds, the Dean of the School of Law, is here. Also, Dr. Jeannie Wayne, the representative of the History Department, Dr. Barbara Taylor, who is the representative of Phi Beta Kappa, who is established as a member of the Trust Committee owing to the membership of most of the Hotz family in that fraternity. And so it is under the work of that committee that this program persists. We're very excited, I think I can say on behalf of the committee, to have three wonderful panelists who will be talking to you today. The comments will be given by Professor Delora Hughes, who is one of the commissioners of the Arkansas Access to Justice Commission. Professor Hughes is a professor specializing in our clinics, who is very unusual in not only teaching in the criminal clinic for prosecution, but the criminal clinic for defense. Not many people enjoy the schizophrenic distinction of training students to carry both sides of criminal justice forward in their curriculum, and it is an honor to have her as a colleague. She came to us after a degree from Duke Law School and having taught at Case Western and Whittier before coming to us, as well as a spell as a public defender and a clerkship. Justice Annabelle Imber Tuck is Commissioner and Chair of the Arkansas Access to Justice Commission. Justice Tuck is an alumna of Smith College and received her law degree from UALR School of Law, now the Bowen School of Law. She was a partner in the Wright, Lindsay and Jennings firm. Governor Clinton appointed her first to be a circuit judge in 1984. Elected to the Chancery Court, she presided over the trials leading to the Lakeview case decisions, which established an equal access to appropriate funding for all the school children of Arkansas, and is one of the bedrocks of education law and the Constitution in the state. In 1997, Justice Tuck became the first woman elected to the Supreme Court of Arkansas, and in 2009, she retired from the Arkansas Supreme Court and is engaged on a fantastic life of public service, not the least being her work with the Arkansas Access to Justice Commission, but also being jurist in residence at the University of Arkansas Little Rock School of Law, which I am very proud to say is a wonderful sister institution to us, and it's a real pleasure to have both of you with us. But we are particularly fortunate to have with us today Professor Frank Michelman. Professor Michelman is known, I think, to everyone who loves the law and has done so the last dozen years in grand style as the university professor of Harvard Law School, which at Harvard, to be a university professor is a very rare and noble task, and he's been succeeded since becoming emeritus by, I think, Cass Sunstein took it here, didn't he? But now he's back after some sojourns in Washington, D.C. Professor Michelman was a student at Yale College and a student at Harvard Law School, and has been on the Harvard faculty as assistant professor, as the Walmsley professor, and university professor. But this pales in comparison to his remarkable scholarship in public service. The list is tremendously long, and I'm not going to tell you all of it. But among the things that I, as a law student, very much fell in love with was his 1969 foreword to the Harvard Law Review, in which he developed what was at that time, I thought, one of the most important arguments for justice, and that the United States Constitution should protect those who are burdened by poverty and should recognize socioeconomic rights, not only by treating poverty as a suspect class or quasi-suspect class, but also looking at socioeconomic rights as a civil right, should be looked at under the Constitution. But this is by no means his only lasting contribution. Among others, all of you will have studied, I hope, the Penn Central case, which relied very much on his opinion and fairness, utility, and property. And his many, many contributions. I not long ago read his wonderful book on Justice Brennan and democracy. But the tremendous imagination and development of his work in property, comparative law, constitutional law, and legal history would not be complete without explaining that he was a principal advisor to the post-apartheid South African government, helping to build the one of the most advanced constitutions and one of the most successful constitutions of the post-colonial, post-apartheid era in the world. And it is a pleasure to welcome first Professor Michael. Thank you very much.
Professor Shepard, why don't you give me one bit of advice? At what ring of the clock do you want me to subside and get out of here?
Well, I'll regret saying any time because I'd rather else all keep going. But I'd say that if you were to go by that clock until perhaps a quarter to, that will give us time for the justice and professor to have their comments and still have a little time for audience participation.
Well, thank you for that. Thank you for that extremely gracious introduction. Thanks to the dean and the faculty and the trustees for making it possible for me to join you this afternoon, for inviting me to do this and have the honor and the pleasure of sharing this discussion with Justice Tuck and Professor Hughes. I'm really very glad to be here. The posters for this event, I think, presented under the title of How the Constitution Should Consider the Poor. And yeah, I am going to talk about that. I'm going to talk about how answers given to that question, how the Constitution should consider the poor, I'm going to talk about how answers to that question that are currently on the rise around the world may be having an effect of shaking up traditional long-standing alignments in debates. They'll be familiar to me, to you, as I outline them in a few minutes. Debates about our understandings of constitutionalism, constitutional law, and constitutional rights. So I said around the world. And I think the next thing I should say is that the set of developments that one can see occurring in various locations around the world where constitutional democracy, in a form that we would recognize as such, is in force. Those are developments that that you can't see visibly on the surface in the United States. I'm not talking in these remarks in particular about constitutional developments in the United States, although I am talking about developments in how we talk and think about constitutions and constitutional law in which American scholars, including quite prominently my colleague Professor Tushnet, whom Steve mentioned in his introduction, have had a major role. So the conversation, developments in which I will be talking about with you this afternoon, is a global conversation. It's not one that is particularly indigenous to this country, but it is one in which some of the principal participants are, in fact, Americans. The developments are in the form of recognitions in constitutional text and in constitutional legal doctrine as derived from constitutional texts by Supreme Courts and constitutional courts in sundry countries, recognition of claims to support of the state and provision by the state at social expense of fulfillment of what are sometimes referred to as basic economic needs of people. So, for example, Section 26 of the Constitution of South Africa provides that everyone has the right to have access to adequate housing. Section 27 provides everyone has the right to sufficient food, water, health care services, and Social Security. Those are laid down as constitutional rights. You don't see anything like that in the United States Constitution. Those of you who are familiar with decisions like that in DeShaney against Winnebago County will understand that claims to the effect that anything like that exists as a part of our constitutional law are simply rejected at the present time by our Supreme Court. I think the situation, in fact, is more complicated than that, and one can see here and there occasionally signs of an outcropping of recognition of something like the moral necessity of recognition in a constitutional instrument or a constitutional system of an obligation on the part of society to make sure that no one falls through the cracks of the economy to the extent at which the chances of full-scale participation in the social, economic, and political life of the country are very seriously constricted. These developments that I'm describing, maybe I should mention another one to give you an idea. The basic laws of Israel, which, as construed and applied by the Supreme Court of Israel, serve as a kind of higher law constitution for Israel at the present time, include a guarantee to everyone of respect for their human dignity. And the Supreme Court of that country has taken the dignity guarantee, has interpreted it in a way that some might regard as moderately expansive, to include a guarantee to everyone of access to the means of a minimally dignified human life, a minimally dignified form of human existence, which depends obviously for every person on having access to a certain level of nutrition, shelter, education, and the like. You might be starting to think that writing guarantees of that kind into a constitution as legal guarantees and as rights that people can go to court to claim might present courts with some difficult challenges, and we'll come to that before I'm through speaking this afternoon. But for the moment, let's just rest with the idea that the political constituencies of many constitutional democracies have come and are continuing to come to see it as a political moral necessity, as a condition of the moral supportability of the state and its authority and its power, that the basic charter of the state, the basic set of commitments on which every citizen can rely, should include some level of socioeconomic guarantees. Now, I want to put before you two, I'll call them traditional positions regarding constitutional rights and the manner in which they are effectuated institutionally in the affairs of a country. And these positions I want to present to you as contrasting. I don't want to quite say contradictory, but as contrasting positions. And I'm going to call them by the name of mainstream liberal constitutionalists, two parties. Mainstream liberal constitutionalists, that would be me, and I feel safe to say a whole lot of you. The other party that I'm going to put on the field, I'm going to call the Democratic left. And that might also include me, but I can't be fully and completely both, not in the way that I'm going to present the positions to you. The liberal constitutional mainstream already indicated this. Sees the Constitution, sees the institution of the Constitution, sees the practice of writing, recognizing, and heeding a political constitution as a crucial part of a response to a basic question of political morality as this party understands the question of political morality. The state is powerful. The state coerces. The state creates and recognizes laws, expects and calls upon all who are within reach, all of the citizens, by and large, to abide by those laws, to respect them, to feel some degree of prima facie obligation to abide by them. And the state stands ready when necessary to do more than expect, to demand and to enforce. And let me put the emphasis on the force syllable in enforce. The Liberal Party takes the position that there has to be some justification for that. That the authorization of legal force can be justified in the eyes of those subjected to it, only if certain preconditions are realized at all times in the life of the polity. These preconditions, some of them are institutional in form. The state's decision-making has to be in some basic, broad sense democratic. It has to be accountable to the people. It has to be responsible. Those are process-related concerns. But some of these preconditions have to do with political outcomes. People have to be guaranteed against certain particularly bad political outcomes. We're talking now about freedom from certain kinds of physical abuse, freedom from unjustified arrest, freedom of political association, freedom of political expression, free exercise of religion, and the like. The traditional classical catalog of liberal civil rights, or as they're sometimes called, negative liberties, because the traditional classical catalog takes the form of a series of thou shalt nots as issued to the state. Now, in a society that organizes its economic life largely through markets, not exclusively so, and not unregulated markets, but in which economic markets, economic self-responsibility are major institutional components. It might be argued that historical experience shows us that as a matter of structural necessity, there will be those who require some source of economic support beyond their own earnings and their own inheritances in order to be able to maintain life at a respectably, humanly dignified level. Poverty can be structural. So we're not talking here only about, say, the disabled. But we're talking about people whose lives begin, take shape, and are led under conditions in which the barriers to full-scale development of capacity and capability and recognition and respect and entry and flourishing in the contestations and engagements and encounters of social, political, and cultural life are very badly and obviously impaired. So just think about poverty as a structural inevitability in a liberal market organized society. And you will see, I think, how thinking can come round to the idea that in some way, in some form, guarantees against lack of access to basic economic necessities would become a part of that package of preconditions on the basis of which we say, granting that those conditions are satisfied, then the free play of democratic politics and the free play of market economics not only can be allowed to go forward, but does justly and appropriately go forward. Well, if you get that far, then you say, well, the Constitution is the instrument where these guarantees are exhibited, where they are publicly declared. And so, socioeconomic guarantees go into the Constitution. But what we're concerned about is not ultimately what's written in the Constitution, it's what happens on the ground. And as with other classical liberal constitutional guarantees, freedom of expression, free exercise of religion, freedom to decide when or whether one will become a parent, a touchy subject in Arkansas. It turns out that they have to be given some institutional locus of enforcement. There has to be some institutional arrangement, not only to call the society's attention to occasions of default on the part of the powers that be, but some socially recognized institutional forum in which correction can be obtained. We call those courts of law. We call the process that's engaged here judicial constitutional review. Right? So you see where we are. The liberal constitutional mainstream, for reasons of this kind, has traditionally stood in support of the role of independent courts to defend individual rights against over-hasty or overzealous democratic political majorities, and all the more insistently and uncompromisingly when truly basic rights, what we think of as the preconditions of the moral permissibility of the exertion of political and legal force, are at stake. So we have an idea of, this is one, not the only, but one important version of the idea of the rule of law. The rule of higher law, constitutional law, as authoritatively rendered by courts. And we get a practice which is sometimes styled, maybe more characteristically by those who don't fully approve of it, of judicial supremacy. Strong judicial review. It's a strong practice of constitutional review that authorizes politically insulated courts to override the legislative acts or the legislative defaults of democratic majorities in the name of a list of abstractly named individual constitutional rights, which the courts then get to construe, interpret, and apply. So liberty means freedom against state impairment of access to abortion services prior to a certain stage in a pregnancy. What that stage is now under dispute between the Arkansas legislature and the latest word of the Supreme Court. I'm editorializing here. But you see what I mean? It's the Supreme Court that took the word liberty in the 14th Amendment and spun it out that way. And so when we authorize courts to do this in the name of political decency, in the name of satisfying the moral preconditions of a justified state practice, we are submitting ourselves, so it is said, to some kind of authority that's external to us in matters that to many of us on many occasions are of the deepest possible individual moral concern. And that's where the democratic left comes in. The democratic left isn't so happy with judicial supremacy. And the democratic left, well, that would largely include the critical legal studies contingent in the United States. The democratic left has been somewhere between skeptical and hostile in its attitude towards judicial supremacy. I want to be careful here. It's not necessarily because the democratic left hasn't shared with the liberal constitutional mainstream the kinds of ideas that I have been putting before you about the conditions, the preconditions of the moral legitimacy of the state. It's It's the entrustment of the specification of what those preconditions are within abstractions, right? Within very broad abstractions such as liberty, expression, association, free exercise. Free exercise doesn't tell you whether the state may or may not provide support for denominational schools. Neither does establishment answer that question. Freedom of expression doesn't answer the question about the constitutionality of the regulation of hate speech. Different constitutional judiciaries in different countries across the world answer those questions differently from the way ours does. It's not that ours is wrong and they are right, it's that the questions are debatable at a level of reasonableness that means that the words themselves in the Constitution don't already contain the answers. And the judges then, or whoever does the interpreting, is exerting a good deal of political authority. This is a problem for the Democratic left. There should be rights, higher rights. They should be respected. They should be carried out, and the interpretation of them should be left with their authors, the people, or the people's elected representatives. Not to a body of politically non-accountable, a relatively small number of politically non-accountable, legally trained, right, legalists who work everything out in a legal, lawyer-like frame of mind, and don't work it out by open, unconstrained, free political exchange. So one of the concerns the Democratic left is about the non-democratic character of judicial supremacy. Another concern, I think it is necessary to recognize, is that the Democratic left, which is a left, which is egalitarian, which is redistributivist, which constitutional rights or no constitutional rights would be exerting control, if it only had control, over the policymaking of the country to make sure that socioeconomic rights are in fact fulfilled, whether the Constitution has anything to say about them or not. The Democratic left doesn't entirely trust the likelihood that those who ascend to high judicial positions in a society like the United States will be fully sympathetic to their political views. The Democratic left thinks that what have sometimes been called possessively individualist property rights will be given greater credence and greater respect in the deliberations of an elite judicial body in a country like the United States than will the kinds of concerns that prompt the addition of socioeconomic guarantees to some constitutions. I don't mean to comment one way or the other about that. Steve mentioned a book of mine about Justice Brennan. He was my boss once, and I wouldn't characterize him or his judicial works or his politics or his thought in terms anything like the ones I have just been using, but he might be an exception. The concern is that over the course of time, the preponderance of the leaning of the judiciary will be to the right and not to the left, and that means you want to get the judges out of this. And trust to the people, trust to the people, trust to the people in their gerrymandered congressional districts, with representatives serving 2-year terms and having nothing more prominent in their minds from day to day about where they're going to get the money to run the next campaign. I'm editorializing again. But you see the two contrasting streams of thought. Now, what I want to suggest, it'll have to be just very briefly, is that under pressure of the recognition of the emergence of socioeconomic guarantees in constitutions. Both sides are kind of showing signs of collapsing towards the middle. You see signs within the liberal constitutional mainstream of moving away from judicial supremacy towards some quite different conception of the role of constitutional litigation and judicial judgment in the affairs of a country. And perhaps somewhat less surprisingly, you see it on the part of the Democratic left, with socioeconomic guarantees now in the Constitution, a recognition that maybe a little bit of judicial supremacy wouldn't be so bad when legislatures are, in fact, not delivering on basic education, not delivering on health care services, not delivering on housing, not delivering on access to justice. Where are these judges? The left now, interestingly, wants to know. Why aren't they acting more muscularly in socioeconomic rights cases? You see, this question can't apply in the United States. It only applies elsewhere in countries like South Africa. There the guarantees are. The courts aren't doing anything about them. Well, the courts are doing something about them. The fact is that a socioeconomic guarantee in a constitution in a country like South Africa, or in just about any country you can name, can't be construed as a promise that you will have a house tomorrow. You can't step forward, go to court, say, I don't have adequate housing, I don't have any money with which to acquire adequate housing on the market, where's my house? The Constitution says I get one. That's not going to work. The constitutional guarantee, consequently, and this is unavoidable, the constitutional guarantee consequently gets interpreted as an obligation, a kind of a best efforts obligation. An obligation on the part of the legislature and the executive branches of the states whenever opportunity shows itself to exert themselves in the direction of moving towards final and full satisfaction of the socioeconomic guarantees, subject to budgetary constraints, GNP constraints, the fact that it's not only housing that I have to supply, but healthcare, education, food, and water, and national defense, and this, that, and the rest of it. And subject also, of course, to the constraint of the civil liberties, that these rights are not to be fulfilled by measures that violate rights to freedom of expression, freedom of association, personal liberty, and so on. It's a complex and hard job. It engages every aspect of public policy you can think of. Monetary policy, jobs policy, import policy, trade policy, family policy, everything. Everything's implicated. Every time the legislature sneezes, the socioeconomic guarantees are in play because someone might more or less plausibly make the claim that the legislature has passed up an opportunity to make progress. And with a guarantee of that kind on the table, you can understand that courts have been somewhat reticent to engage themselves too sharply and too strongly in this business. And so courts fall back on doctrines like reasonableness. We will call the legislature's attention to the fact that we think that its policy in this, that, or the other respect has not been all it reasonably could have been. But what kind of order does the court issue? It issues what's sometimes called a structural interdict or a structural injunction. It says to the state, would you go back and think about this and then come back and talk to me and we'll see. So here's the Democratic left. The Democratic left said, you don't enforce property rights that way. When someone's property is being occupied by a homeless person with no lease, and that property owner comes to court and says, I need an eviction, you give him the eviction. You don't shilly-shally around that way with freedom of speech. You don't shilly-shally around that way with abortion. You cut ice. Judicial supremacy. So the Democratic left now says, I want to see more muscular judicial enforcement of socioeconomic rights. Now the Democratic left, under pressure of the coming into existence of socioeconomic rights, is moving in the direction, moving in the direction of judicial authority. The liberal constitutional mainstream, under pressure of the kind I tried briefly to describe, what are we going to do with these socioeconomic rights? There must be some conception, there must be some notion of constitutional bindingness and judicial authority that isn't judicial supremacy, because judicial supremacy won't work with these rights. But these rights are important too. And what we are getting, have been getting, over the past 10, 15 years, coming out of the liberal constitutional mainstream, is a literature of so-called weak-form judicial review. Mark Tushnet has been a major contributor to it. Now you might say, Mark Tushnet's a crit, he's not part of the liberal constitutional mainstream, but he is a part of the liberal constitutional mainstream. And, I'd be happy to discuss that if you wanted to, but the fact is he is. What are these weakened forms of judicial review? Well, they're non-final. The Canadians have it written into their constitution, their Charter of Rights, Section 33. Notwithstanding the Supreme Court's declaration of the unconstitutionality or the uncharterish quality of an act of a Canadian Parliament, the Parliament can simply go back and reinstate it for a period of 5 years. It's subject to a sunset provision. They have to reenact it later if they want. And so the Charter institutes what has been called a dialogue between the court and the legislature. The court has a role. There's bindingness of a kind. What the constitutional guarantee binds the country to is a serious conversation. It binds the legislature to deliberate over the best interpretation and the best form of implementation of the guarantee. It binds the court to respond to citizen complaints brought before them by whoever is considered to have standing before that court. That obligation, the obligation of a genuine, focused, democratic deliberation looking towards fulfillment of the guarantee, is not occurring, as can be seen, the claimant might say, from the state of affairs on the ground. And the court then officiates, calls attention to defaults and defects in the deliberative process, kicks things back to the legislature to try again or think again, but does not undertake to say, I'm thinking now about a recent highly contested case in South Africa, does not attempt to dictate to the state the numbers of kiloliters of water per person that has to be supplied in this, that, or the other municipality in South Africa, right? It's not judicial supremacy anymore. It's weak form, dialogical, democratic experimentalist, catalytic. There are a lot of names for it around in the literature, judicial review. It actually is a rather deep alteration of our understanding of what a constitutional right is and what it means for a guarantee to be legally binding and what it means for the guarantee to be law. And it is quite far distant from the traditional liberal constitutional mainstream conception that I began by putting before you and that I imagine most of you were sort of nodding comfortably to, judicial supremacy, as I put it before you. Is there any spillover then to how courts are going to approach the classical liberal constitutional rights, the negative liberties? Are we going to have, instead of New York Times against Sullivan, are we going to have a Supreme Court that says, well, we think that you could have written your defamation law with a little more respect for freedom of political expression, so we want to kick that back to you to consider it again and then come back and tell us what you did. Well, I don't know if it'll ever get that far, but the Canadian system that I've described to you is actually looking precisely in that direction. So, okay, I have to sum up here. Faced with constitutionalized socioeconomic rights, the Democratic left newly and freshly sees the point of having constitutionally binding preconditions for the moral legitimacy of the state and having some precise and specific institutional setting in which some kind of accountability can be imposed on those who are responsible for performing the conditions. Faced with constitutionalized socioeconomic rights, the liberal constitutional mainstream sees that judicial supremacy can't work there. Has to come up with some modified form of judicial oversight. And once that modified form of judicial oversight is in circulation, there is no telling whether it will move into the space of the classical liberal negative civil rights or not. It may. So there's my story. The poor we have tended to think of as the forgotten or the orphans of constitutional law. And what I have been suggesting to you is that a concern, a moral concern, a political moral concern for the condition of the poor, of all things, is now in the process of, go back to where I began, of shaking up traditional, long-standing alignments in debates about what we mean by, what we understand by constitutional law and constitutional rights and bindingness and law in general. So, thank you very much, and I'll look forward to any discussion that we might have time for later on.
Thank you very much, Professor Michelman. Justice Tuck and Professor Hughes are going to speak from their chairs, and they'll, at the conclusion of their remarks, then we'll have an opportunity for questions and answers. Now, I understand that we have a 5 o'clock class that some of you will have to leave to. Please be gentle to your friends as you come out to go to the side. So I regret this, but we do have some courses that are still running this time of day. So.
Well, thank you very much, and I was pleased, actually, as I listened, Professor, to your discussion of this week judicial review, to think about an actually most appropriate issue that came before myself as a trial judge under the Arkansas Constitution, and then I held a ruling, and it was on school funding, which of course is an issue that's going on all over the country. But we had a provision we have a provision in our Constitution that provides for a general and suitable education. And as a trial judge, I was faced with, made a good record, that if you were born in a certain part of this state, you only got a couple $1,000s per year per student, because the property tax base was very low. And then if you were born in another part of this state, kind of like up in this neck of the woods, you'd get $6,000 a year per student. And of course, I had some other case law from Tennessee, Kentucky, Texas, and it seemed to me it was a lay down hand. And I held the whole system unconstitutional. Now that creates a problem that the South African judges had with water. So what do? Close down the whole system of schools of Arkansas, like in one day? That doesn't really work, and I realized that, and I came up with a solution that sounded a little bit like what you were talking about. Actually, it had been done somewhere else, and said I would give the legislature 2 years to fix it. Well, it went up to the Arkansas Supreme Court, and meanwhile, I can't sit on the case. Now I'm on the court. So I'm off the case, but I'm watching my colleagues deal with this. And I had some colleagues who just shook their heads and said, this isn't a final order. You've given them 2 years. It can't be appealed. They sent it back to the trial court. Meanwhile, I was gone. Another judge had to take it up, and finally, a final order comes up after a bunch of yeah going on. And I'm still not on the case because they're still going to be judging my opinion. And so the court takes up the case and has the same problem. They affirm that it's unconstitutional, but are they just going to say it's unconstitutional and close the book? And
What they did in Massachusetts.
yeah. Well, not our court. It was a very interesting, it was interesting. There was, Justice Glaze is really, he wanted a final order and close it up, and if the legislature didn't fix it, then come back with another case. Not this case, another case. Well, the majority didn't buy that, so the majority basically did what you're talking about. The majority said, we're saying it's unconstitutional, we're going to appoint masters. They appointed former Justice Newbern, former Chief Justice Brad Jessen. They had masters, and they went and did all this analysis. And then they said, after a particular period of time, to give the legislature to change some things, which they actually did. Our current governor was a senator then, and they came along and had a new constitutional amendment on property taxes. Everybody had to have 25 mills, all across the state, minimum. I'm not going to talk about the recent decision where it's not a state tax, but anyway. So everybody comes back to the Supreme Court, and the Supreme Court says, not good enough yet. This was all about what is an adequate and equitable school funding formula. And so it kept getting bounced back, so the heat, the fire, kept going back to the legislature, so they had to stay on top of the issue. It was a perfect example of what you're saying. And I was sitting there going, because I will admit to you, I was going, this is a new ballgame. Our Supreme Court has never, in this kind of case, appointed masters. This was the first time, and I will tell you, the legislature did step up to the plate. And I think, began a process that I hope ensuing governors will, and BB is definitely committed to it, but in our next governors, that education will be a priority. But that is socioeconomic. That was a definite, what is a adequate education? So the legislature had to go figure that one out. What is adequate? And so I wanted to say, well, we did it by hook or crook. We may not have known what we were doing, but we did it. Now, we haven't done it in any other type of case that I know of. Usually, there's straight ups and downs, and it's unconstitutional. And that's my colleague of blessed memory, Tom Glaze, said it's either constitutional or it's not unconstitutional, or it's unconstitutional, and you can't have it both ways. You can't have schools still operating if they're unconstitutional. But anyway, that was what I call weak judicial review. I'd like to go to another topic and then cede to my colleague. And that is, obviously, as the chair of the Arkansas Access to Justice Commission, I have a problem. And that is, am I going to talk about justice or am I going to talk about access? And to be candid, today, our problems in Arkansas are really access. And that means procedural. How do we make those rights we already have in the law accessible to every citizen of this state, despite their inability to afford a lawyer or to even be able to get to the courthouse? Because transportation, we have 25, well, over 20 to 25% of our people live under the poverty line. That's about 500,000 people. We have 2 legal aid providers in this state who try diligently but just touch the surface. So my commission and my view is that what we need to do is shake up the way we deliver legal services. And that it can't just be expecting a client to come to a law office. It has to be take the service out. We have medical legal partnerships now out in the Delta where we are having pro bono lawyers go out there as well as legal aid lawyers, and they come to the doctor. Everybody either in Arkansas, and I'm sure elsewhere, goes to Walmart, goes to the doctor, or goes to church. Okay? Or their local synagogue. Okay? So I'm just telling you that that's where you find people. And what I'm looking at is how can we look at how to help people represent themselves, unbundle legal services so that lawyers can take parts and thereby be able to, so to speak, be affordable to people. And then I've gone around and just been shaming lawyers right and left about pro-bono, just shaming them and telling them it's almost a moral imperative, not just an aspirational imperative. So if we don't make access better, then we have basically fallen down on the moral imperative. I mean, you can have a lot of rights, but if you can't enforce them, what good are they? I mean, I could even negative rights. But these people, it's about landlord-tenant, where we're trying to get a new landlord-tenant law passed. We have no rights for tenants in this state, none. So we had a commission, one of our professors down at Bowen set this up, and now we've got the report to the legislature, and now we're starting that process. So for the first time, as a judge, since I'm not bound by the Code of Judicial Conduct, I am raising money for our foundation to get money to pay for legal aid and to go to foundations, to go to corporations, because we can't rely on LSC anymore. They're going to cut more funding from legal aid. We've already had to fire people. And so I don't think we can just rely on one source of funding. I think we have to diversify like any good business does. So I'm sitting here probably on the first base. You're way out there with stretching to get us a better minimum. I say you're discussing it, okay? But I'm saying about, which I agree with, by the way. But I'm sitting here still on first base to even get somebody to the courthouse. So I'd like to pass it on to... I would like to pass it on to her because we have talked about how many lawyers there are per citizen qualified for legal aid and all this. And she's done some statistical work to look at what does that really mean when you average things. That's really kind of deceptive. So
I think I'll give you a little background. When Justice Tuck and I first started talking about this, of course we had the benefit of getting to spend time to read some of the professor's work and the articles, and what we started talking about was macro versus micro, right? And the idea of the benefit that everybody in this room has of sitting around and thinking about these things and talking about the shoulds. And then we think somewhat, I was just telling Director Thompson earlier, I spent the morning in court, and I'm thinking about what is actually happening versus what should be happening, maybe what our law says versus what it's actually doing on the ground, right? And when we started talking about that macro versus micro, one of the things that came up was the idea of legitimacy and a perception of legitimacy. And I think this connects back to what Justice Tuck is talking about in terms of both access and access to justice. How do the poor perceive the system itself? Do they perceive it as legitimate? Do we perceive it as legitimate? And when I listen to you speak, and again, I would say, just in case anything I say in the future comes out badly, I agree with the notion of creating a system of where people have access, automatic rights to water and housing and food and certainly the basic necessities. But what I think about is, if I said that to somebody that I represent, we in the clinic, of course, represent people who are living below the poverty line that Justice Tuck described, would they believe me? And if they did believe me, then would they know how to go make that happen? So if we gave them that right, if we gave all of us that right, what would we do about it? And I've been thinking about some of the conversations that I've had recently. I'm going to hopefully not editorialize too much with some of our legislators lately about various and sundry topics that are going on. And one of the conversations that I had was with a fairly recently elected legislator who is not a lawyer by career. He's a graphic designer. And one of the things that's great about him is his very open and sort of honest positions about how he has learned, right, about the system and participation. And one of the things he said is that it's very interesting to note who he gets bill suggestions and bill ideas from, right? And because the idea, right, for those of you who don't know, maybe some of the students in the room, the idea is that the legislature is open, right? If you have an idea about something that should become law, you can submit that to your representative and hopefully have that proceed forward. I would say that most of my clients probably don't know that. And I would say that the ones that do probably have no idea how to access that system. And even if they did, they probably have very little faith that their ideas, notions, etc., are going to proceed forward into becoming. I have how a bill becomes a law in my head now that I've started that. So when I listen to this, and I love the debate of the idea of judicial review versus our legislature, etc., what I would put back is, I'm not sure there's faith or perception that the perception is that either side is legitimate in terms of what Justice Tuck started talking about, which is the concept of just access, much less access to that justice. And what this all begs for me is, while I love the idea of additional rights, basic rights, I don't think they should be additional. I think they're probably the ones we should have started with, is that, as you described it, Professor, the institutional arrangement. To me, it begs the question of, should what we really be doing is scrapping the entire system and changing, I know, right, I heard heart stop beating for a second by some of the faculty, is the whole thing out of whack? Does it really need to come down to a question of finding the middle between judicial review and legislative review or legislative creation, or is there something else that we've done or set up that's fundamentally incorrect that we can't correct now just by either adding additional rights or searching for a solution within the system as it currently exists? What Justice Tuck is referring to in terms of the data, I will admit readily that I am still at amateur status when I've not gone pro yet on the empirical collection of data. But when I first got here to Arkansas and started my work with the commission, we talk a lot about the state, right, and what our rankings are and the status of the poor. And she told you very correctly that data tells you that we have about 25% or more of our population in the state living below poverty. That puts us at a rank of third in the nation. And just to give you a couple other statistics, because they're fun for me now. We are 5th in the percentage of children under the age of 18 that are living in poverty. We're 3rd in the lowest median household income. 3rd in the percentage, and this is rank, of course. This is not the time where we want to be 3rd. We want to be like 40-something, right? 3rd in the percentage of grandparents responsible for their grandchildren, meaning people not being raised by their biological parents. 2nd in the percentage of population in the state that is disabled. And 13th, that's a good one for us, 13th in the percentage of those living without health insurance. So when we talk about concepts of access, we have to have all of this information in mind. And when I first got here, I looked around Washington County and I thought, wow, Arkansas, this is great. We're doing really well. And I went to Benton County and I saw the same thing. And then when I joined the board of directors for legal aid, I drove out to Jonesboro. And my vision and my perception of what access and access to justice looked like changed as I drove east. And then we had another meeting and I drove southeast. And I went, oh, Arkansas. Okay, I get what we're talking about now. And so we talk a lot about, and that is, by the way, for those of you who don't know, when we look at the percentage of people who live in poverty, on our eastern, I'm saying coast, I don't mean coast like there's an ocean, I get, we're not waterside. That eastern coast, better than 30% in most of those counties are living below poverty. But we talk a lot about, and I'll give you some basics here, the recommended level of the level of access according to the Legal Service Corporation is 1 legal aid attorney for every 5,000 low-income residents. In Arkansas, as we stand, we're at 1 legal aid attorney for every 12,250. Now that's an average, right? And I'm so bad at this joke. I really should have looked it up before I came. But there's a joke about, a bunch of people in a bar, sitting around in a bar, and their average income is $50,000 per year, average. And then Bill Gates walks into the bar. And now their average income is about $1 million per, right? It's funny, you should laugh now, but I'm not telling you. Anyway, the point, you laugh maybe at me, but still I count it. The point is that average is misleading. The average means very little when it comes to access to justice in Arkansas. For example, Benton County, our ratio, now you would think Benton County, right, doing really well. Our ratio is actually 1 to 12,763. So we're fairly reflective of the average. That ratio goes up to Craighead County, 1 to 21,000. And that's not the lowest one. There's more. Now that average is still, actually when you do the current numbers based on population in poverty, our average went down. Now we're down to 1 to every 11,139. But it demonstrated to me a couple of things. The first is that the average, as that joke tells us, is fairly meaningless. And the second thing is that we need to think about what that means in each individual county. That the macro is a great conversation to have, but we need a conversation about what that looks like on the ground at the micro level as well. The other thing in looking at some of our statistics, what I basically did is I went out and I pulled the Arkansas data for how many lawyers there are in Arkansas, and I looked at legal aid lawyers, and I did it by county instead of by average across the state. And then I wondered when I was looking at that, well, what's the correlation here? So if we're talking about there's one legal aid lawyer for every 12,250 people, whatever the number may be for your county, how did we determine that one lawyer should be there? How do we divide up those resources? So I ran some tests and decided, well, I would think that we would divide that based on median household income, right? There should be some correlation between income and resources, right? In places where income are lower and poverty is higher, you'd see more legal aid lawyers. You see more lawyers working with people in poverty, etc. There's no correlation in any county in Arkansas. So I guess all of that to say, for me, I go back to questions of the perceptions of legitimacy of the system generally, and the overall question of does it matter whether our legislature, current or otherwise, is making these decisions, or whether our judiciary is making these decisions, but whether or not the people who are being served by either, preferably both, of those groups perceive either system to be legitimate and how they then make that access. So to me, I love the macro discussion, and it's definitely one that needs to be had, but, and I'm not sure we're ever in the U.S. willing to follow Canada. I'm not sure how we feel about being second to Canada. But to me, it creates a system of, we need underlying structural change across the board. It's not about whether it's judicial review or legislative review. We need an underlying fundamental change in how we provide, as Justice Chuck said, whether or not we're even getting the rights we currently have to the poor, much less additional rights. And with that, I think we're opening it up.
Yeah.
Thank you both very, very much. Before we turn to audience questions, I wonder if there anything among the three of you that you'd like either to respond to or to query one another before we turn to the audience.
I'll say a word.
Please.
First, let me start with the business about the U.S. following Canada.
I knew I was going to get in trouble for that.
No. It's very perceptive. The fact is that the Canadians don't follow Canada. They follow I told you about a section of the charter that says that provincial and national parliaments have the power to declare that notwithstanding the unconstitutionality of a law, that they're going to stick with it for a while longer. The fact is, whether or not this was an inevitable development or whether or not it's an accidental development owing to some contingent events that occurred in the early years of the system, that it's not used. Canadian parliaments don't do it. I think it's fairly clear that they don't do it because they anticipate hostile reactions from the Canadian public. If the Supreme Court has said it's unconstitutional, and you should be out of there. Judicial supremacy is in the fabric of the understanding of the Canadian citizenry and the dialogue that was charted by Section 33. There are dialogical features of constitutional adjudication in South Africa, but this is not one of them. So, we're not following Canada. Canada is not following Canada. Canada is following us. Now there's a second point, right, about Professor Hughes' remarks. It's her thought about our being, that we've got this entrenched set of constitutional and institutional understandings. There are designated lawmakers who make laws. Citizens are expected to abide by the laws. Courts are expected to interpret and enforce the laws. And somehow or other, this system, as a whole large construct, doesn't seem always, I don't think we can say ever, doesn't seem always or close enough to always to be delivering the goods of justice. So maybe we really need some more radical kind of thinking than anything in my remarks would have suggested. My remarks are directed to, absolutely, a debate that takes place within the tradition of constitutional democratic politics, right? It's a debate that takes place amongst players within that system. So then let me quickly tie that up with ideas about legitimacy and about access. Legitimacy is a central category for people who think about liberal constitutionalism in the way that I do. The Constitution is supposed to be the guarantor of legitimacy. The minimum guarantees of the Constitution are supposed to be a crucial part of what makes it reasonably acceptable to every citizen that they should be expected to go along with the outputs of this system, many of which they will not like and with many of which they will disagree, right? And I can point you again to the legislative action recently taken in Arkansas. Citizens are expected to abide by that if and insofar as it is constitutional. And it's that except and insofar as qualifying clause, right, that's supposed to give an overall sense of legitimacy to the system. And so, except or insofar as their basic socioeconomic needs are met, arguably is an appropriate addition to the set of conditions. But not just as a matter of what's written on a piece of paper. Of course, legitimacy in this sense, that is to say, the citizens' awareness that certain kinds of commitments are in force, constraining and motivating the system of lawmaking with which they're expected to comply. That means they are in force. That means they are carried out in practice. That means that to the extent that access to a judicial forum is a part of the process of seeing to it that they are carried out in practice. And I put it as a question because Professor Hughes has rightly raised the issue of whether that ought to be a part of the deal or needs to be a part of the deal. But insofar as for the time being it is a part of the deal, then the legitimacy condition isn't satisfied by having a clause section like Section 26 in the South African Constitution. The legitimacy condition is only satisfied if the thing is done, is observably and visibly done. And that takes us then back to access, which is a part of justice, which is contained within justice in this legitimacy sense of the term, of which we are converging.
Would either of you care to respond?
I said, open it up.
Well, I will say one thing, Professor Michelman, you might be pleased to know now that the University of Arkansas has its representatives of the critical left, in case you've been wondering.
I wouldn't be surprised.
I'm just critical and sitting on the left.
Absolutely. But are there questions? And given the hour, I would really appreciate people framing questions in a relatively pithy manner, rather than making statements that might require a great deal of analysis. Questions? I'm looking at a lot of excellent questions.
I have an observation that it's been my experience, and I have some experience on the bench, that the effectiveness of legal services generally offends those in power.
Yeah.
And as a result, we now have landlord-tenant laws that are
Yeah.
oppressive. And that was, and I think that was a direct relation to so many tenants showing up with lawyers from legal services
Right.
challenging the landlords.
Right.
And they got the laws changed.
Yeah.
They had the power. The same thing has happened in our workers' compensation system. And it's the people who have the money to contribute to the legislators, to be elected, to make the laws the way they want them to be. Now, that's our system. But I would say to Annabelle, that, and to paraphrase Winston Churchill, never have so many owed so much to so few in the state of Arkansas as those 7 justices of the Arkansas Supreme Court.
Right. Other questions? Yes.
The vision of a society in which every human attains that full-scale human development, as you mentioned, is as old as humans themselves. What is your vision for the U.S. in, say, 25, 50 years? How do we get there, and what are some of the most significant obstacles that we face?
Well, I don't, I'm sitting here and I'll try to answer, but I have to preface this by saying I don't regard myself as a highly qualified political pundit of any kind. It could be that within the period of time you mentioned, that we will have full economic recovery, that we will have a productive economy, that we will have a rising tide that lifts all the boats. It could be. It hasn't happened in history yet. But could be. If that doesn't work out, then, here's a second possibility. It could be that we now have, without any constitutional rights, it could be that we now have on paper, in the form of legislation, administrative practices, agency rules, and so forth, a set of guides, rules, and policies that, if carried out in good faith, would get us to a point of economic justice through the basically economic conservative vision of markets that don't need any greater regulation, right? You've got all these progressive landlord-tenant laws. And according to some economists, one consequence might be that the powerful real estate lobby gets back in the legislature and throws them all out as a matter of backlash against having the courts and the legal aid lawyers monkeying around with the system and getting beyond where their proper place is. Another bad consequence is that you get the laws and what we used to teach our people and how we used to put it in the first year property course, some of us more seriously than others, is you get parking lots where there used to be tenements. And parking lots aren't as good for people who can't afford anything except tenements as tenements are. So there's a lot of tricks here. But it could be that a country like the United States, if it actually followed out on all its existing policy commitments, without corruption of both the gross and subtle kinds, without the deviations from the straight and narrow path of policy that influence can bring, that's the right prescription. Basically, a market economy with a few safety nets around, and let it go, and we'll get there. That's a possible outcome, but it hasn't yet happened that way in history that I know about. In a basically liberal market economy, poverty is structural, and the poor we will always have with us unless we exert ourselves quite specifically in a remedial and corrective way. So that means politics. Some modification, some change in policy has got to have something to do with it. And there, I have to tell you, I'm sitting here on the 7th of March, 2013, but not being any kind of political wizard, really. I'm not optimistic. I don't see our politics as being in very good shape at the moment, and I don't mean that's because the left is somehow or other underrepresented or anything like that. But we don't seem to have anything approaching a genuinely dependable, deliberative politics, at least at the national level, going right now. We've worked ourselves into an extremely adversarial, party competitive, gaming. Point of it is to win the next election, not to generate wise public policy. I'm cynical about this, and not optimistic. But it's a great country, and we may find our way out of this. I'm not the person to tell you the path.
Would you care to comment on Justice Roberts' surprising decision in the Affordable Health Care Act.
Well, here, I'll begin my response to that by bragging a little bit. A year ago from now, when the case was still under advisement, at a number of different gatherings and events that I attended, a dinner of professors from across Harvard University, Yale College class reunion, I won't tell you which year. And people would ask me about it. I'm supposed to know something about U.S. constitutional law. People would ask me about it, and what I said was, everybody's got their eye on Justice Kennedy. I think you might want to put your eye on the Chief Justice, because I said I thought that the Chief Justice's vote would more likely be decisive. Well, the way I put it was, he's going to be in the majority. I thought, if Kennedy went with the four liberals, as we call them, but not what I meant by liberal, that Roberts would surely be with it, that he wouldn't split apart that way. But I also thought there was a possibility that Roberts might be the decisive vote. Now, what I did not foresee was that he would be the decisive vote because he would uphold the individual mandate as a tax. That was beyond the imagining of just about everyone, and I won't claim to have foreseen that. My beloved dean, Martha Minow, wrote an essay. It was published in the Harvard Law Review last November, commending the Chief Justice's judicial statecraft in avoiding a catastrophic result of holding Obamacare unconstitutional, and by doing so through a doctrinal path that, as she envisions the case, was honestly held by him. That is, he thought hard, he thought it over, and he saw the light. And, now, another friend of mine, Randy Barnett, who teaches law now at Georgetown, and who was the first person in the field and the most vociferous voice in the field throughout among constitutional pundits in the United States, to the effect that the individual mandate was a stretch beyond the limits of the congressional power to regulate commerce among the several states, right? Because this wasn't the issue. The issue wasn't whether it's a violation of individual liberty as guaranteed by the Due Process Clause. The issue was whether Congress has any enumerated power on the basis of which it could do this. Barnett thought up the argument that prevailed with 5 justices of the Supreme Court, including Chief Justice Roberts. And Barnett has just posted on SSRN. Most of you know what SSRN is. He's just posted the draft of an article in which he says, see, because what he's doing, he's saying all the liberal, meaning blue state now, all the liberal law professors in the country are refusing to see that they lost the case, and that there is now a firm holding by 5 justice majority of the Supreme Court that you can't do that under the commerce power, which is what I've been saying all along. So people will argue and wrestle over who won, who lost, and whether Roberts certainly was careful and thoughtful and practicing some kind of statecraft in his judgment, and he did brave and face the predictable wrath of his base, if we can speak of Supreme Court justices as having bases, and he must have understood that that would happen. But he managed, right? He managed to avoid what could have been a very dangerous episode in the history of the Supreme Court and its legitimacy, its authority in the political system of the United States. Holding that statute unconstitutional would have really been something. And it would make you think certainly of the mid-30s and FDR's response to the Supreme Court. He managed not to do that and still to lay down for future courts to have to deal with some kind of limitation on the commerce power that could come home to bite the left in the rear in some way that we cannot now easily foresee in the future, because there may be something that you can only do with a regulation and that you can't do with a tax. I don't know what it is, but there may be.
Well, in the light of the hour, I know that there are a lot of questions that are still begging to be asked, but I have good news and bad. Our time here is done, and it is not done, because we're going to adjourn, rather than leave, to the Six Pioneers room on the ground floor, where a reception awaits us. And so if you would join us down there for a few minutes, and you have questions without being too compelling to our panelists, you have an opportunity to visit then. Now, I have two other quick announcements. One of which is, if you do have a CLE form, would you please ensure that I receive it? If you need the form to be returned for credit with the bar, please make sure that I get it so that I can turn it back into Ms. Payne. And then lastly, it is my pleasure to ask you to thank again our panelists for a wonderful afternoon.